This week's hearing has been what is known as a waiver hearing. It is not a trial on guilt or innocence as we customarily see on television, but it's a hearing to determine whether the criminal case of the accused, Jesse Osborne, will be handled in family court or in adult court, the Court of General Sessions. In many ways, a waiver hearing is sometimes described as a sentencing hearing because of the vast discrepancy in the possible sentences that could arise from this incident. If the case were to remain in family court, the defendant would be released with no supervision when he reaches the age of 21. However, if the case is removed, or what we generally call waived up, to the Court of General Sessions, he could face a much longer penalty, even up to and including life in prison. The issues in a waiver hearing focus primarily on a case called Kent versus United States, and you may have heard during the hearing references to the Kent factors. The case specifies 8 factors for the court to consider in reaching a decision on the state's motion for the juvenile to be waived up. And as I said, most of the testimony we've heard this week centered around those 8 factors. I have listened carefully to the testimony in this matter. I have reviewed the exhibits presented. I have observed the demeanor of the witnesses as they testified, and I have determined the facts as presented. And I've applied the Kent factors to those facts as I determined them to be. I find that after due consideration of this information, the evidence points conclusively that the state's motion to waive the juvenile to General Sessions Court should be granted. And I therefore will order and direct that the case involving Jeffrey Osborne be waived up to the Court of General Sessions, where further action on this matter shall proceed. Having determined that the defendant shall be treated as an adult, all of the customary protections afforded a juvenile are hereby extinguished. Now, any motions or any further comments from anyone? Mr. Epps?
We have 10, my understanding is we have 10 days to
That's correct.
appeal. Your Honor, there's been some efforts by the media over the course of this week in defiance of the court order to take photographs or images of my client. I have dealt with this many times in General Sessions, and what I would propose right now is that if the cameras that are over there want to take 30 minutes of my client, 30 seconds of my client's image and put it out there, I would ask that the juvenile facility and the transport vehicles and trying to get a shot under the jail somehow and otherwise harass the court staff and personnel, security staff and personnel, we're willing to do that. And I'd ask that we do that instead. I'm also fully capable of walking out beside my client, and I promise you they won't get a good shot.
Well, I think those are appropriate requests, and I will ask the media to honor those requests as well. Anything further?
At this point, I'm going to step back. If they want to video, they should feel free to do so.
All right.
That's all I'll say.
Thank you. Anything further, Mr. Smith? All right. Anything further from the state? I'm sorry? Yes. I will prepare a written order. I will be glad to communicate with the attorney with the solicitor's office who prepares the order regarding the 8 factors as I determine them to be. I think that
30 days or is that too long?
that's fine. That's fine.
Your Honor, rather than have them send the order and be frantically trying to respond to it, could I ask that either I be provided a draft before the 30 days are up, or I would give us 10 days beyond their 30 days to respond?
It's my customary practice to provide drafts of the order to both sides so that both sides would have the opportunity to respond before I review and sign the order. So I will certainly order that to take place as well. Anything further? Thank you very much. That will conclude the hearing.
Your Honor, I would ask if that's enough time for the meeting. We've got enough. Your Honor, can you ask the cameras to be turned off now?
All right. Any objection to the request to turn off cameras? Or at the very least, no longer show the juvenile photograph at this point.